Right now, the parties are required to each pay 50% of any child care expenses. That was an agreement that they reached in their original judgment of divorce. We're simply asking that the child support provision not be 50-50, that it be pursuant to the appropriate Michigan child care formulation.
No! Ain't nobody got time for that.
You better buckle up your seatbelts for this one, because this one is a doozy. Title: Entitled Mom Gets New Husband and Now Wants More Money from the Ex-Husband. Ridiculous, right? The sense of entitlement that they bring into the courtroom is absolutely ridiculous. Not only is she newly married, but has a new child on the way. So of course, she must have ample reason to ask for more money from the ex, right? Let's get active on this one. Without further ado.
Calling case 2022-2134 Aaron Gentry versus Peter Gentry. Today is Monday, July 22nd, 2024 at 9:50 a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Thomas on behalf of defendant. This matter is before the court on the plaintiff's motion to modify support with regard to child care expense. Ms. McNiff.
Your Honor, I would just note for the record that my client is recently remarried and her new last name is Tinsman. This is really a pretty simple motion. Right now, the parties are required to each pay 50% of any child care expenses. That was an agreement that they reached in their original judgment of divorce. Since that agreement was reached, my client is on has a different job. She's remarried. She has a baby. She had to leave her previous job, which still had her making significantly less money than Mr. Gentry, as a result of there not being sufficient PTO, sufficient sick time. She, at one point, was taking care of the children when they had COVID during Mr. Gentry's parenting time. The kids have had some significant medical issues, some like tube surgery, things like that she's had to take time off for, and she simply couldn't do it with the previous job. So she took a remote job so that she could meet those obligations. We've also been in court a lot, which was a difficulty for her and with her previous job.
First off, shout out to the Abe Lincoln on the bottom left-hand corner of the screen. At first, I thought that was the judge. And I find it so odd that she's entering in that she had to take care of the children due to sickness, right? Like, isn't that what a parent is supposed to do? Did I not get the memo that you can go back later and cry about it in court while asking him for more money for your courageous duty? Now let's see how much this harpy wants from the ex-husband and more reasons why.
So we're simply asking that the child support provision not be 50-50, that it be pursuant to the appropriate Michigan child care formulation that would assign the parties percentages. We do have this matter currently in front of referee Snyder on a change of domicile request, change of custody, change of parenting time. However, this particular part of the child support formula was not at issue. And I think in order to get it there, either the court needs to rule on it or send it to referee Snyder.
Okay, thank you. Ms. Thomas, any response?
I do, Your Honor. I don't think it's as simple as what Ms. McNiff purports it to be. Our answer to the plaintiff's motion certainly sets forth the defendant's position regarding the 50-50 child care. However, I would add that I just want to clarify a couple of things. First, at the time of filing our answer, this motion hearing was scheduled for last week. So we had said there was 9 days before we'd be in front of court again. We're actually in front of Mr. Snyder again on Wednesday of this week. And so there's no reason that this motion couldn't have been brought at that hearing. This is just an extra motion for no particularly good reason other than it cost Mr. Gentry a lot of money. But more to the point, the parties negotiated and they reached, it was by the judgment of divorce was entered by consent. And part of their negotiation was that because Mr. Gentry for a while was working at home, because that was part of what his job was doing. That's not the case anymore. And there was some variables, but the parties agreed that it should be 50-50. And that's what they agreed to that. And that's part of the other issues in the case settled because of that. So therefore, that was a negotiated agreement and it wasn't part of it. And if you look at the uniform child support order, although it's purported that it's in there, it's not in there. And if you look at the formula that's attached, the calculations attached, it's not on there. It does not say that at all, because the parties had agreed that it was going to be 50-50. If it was summer, if it was before and after school, whatever it was going to be 50-50, because that was part of the settlement that they reached based upon all the totality of the circumstances of their particular case. For clarification, in plaintiff's motion regarding change of domicile, she specifically requested relief as it relates to childcare in this matter. And Mr. Snyder has in fact heard testimony as it relates to the issue of childcare. In plaintiff's motion regarding change of domicile legal residence, although she indicates that she's also asked for custody and parenting time, in her motion, that's not true. In her motion, she acknowledged childcare expenses for the children under the age of 12 are to be paid 50-50, and specifically requested reimbursement regarding questionable childcare expenses. So this issue of childcare between these parties is already in front of Mr. Snyder, and he's already heard testimony. So to have another motion that we can again prepare for yet another motion, another thing is.
So let me get this straight. So you consented and agreed that you will be sharing expenses and custody at 50-50 when you decided to divorce this man. Then now, after you heard that he's earning significantly more, now you want to start asking for more money just because. You cannot make this ish up. Ma'am, you are remarried. You have a different last name. You have a new baby on the way. You need to grow up. Even Abe Lincoln down there is side-eyeing you. Now let's listen to the real reason why this woman requested this hearing to take place, and the lawyer's about to cook. Short break from the content to share very important information. Hackers recently gained access to national public data and leaked names, social security numbers, addresses, and phone numbers of billions of US citizens onto the dark web. Thankfully, I feel secure because I personally use Aura, today's sponsor. Aura monitors your personal data, including your social security number, across billions of data points like the dark web and public court records to alert you about potential identity theft. Utilize my link in the description box down below for a free 14-day trial. At least in those 14 days, check if you've been compromised. Plus, Aura offers a variety of other features to keep you safe online, including real-time alerts for data breaches, a VPN for secure browsing, a data broker opt-out to stop companies from selling your personal information, and much more. Again, click my link to try 2 weeks for free. Now that's aura.com/MTR, and that'll be more than enough time for Aura to find out if any of your personal data has been exposed.
Ridiculous. And also, frankly, one of the many reasons that Ms. Gentry used to persuade this court that she should be allowed to take the kids with her to her new boyfriend, now husband's home in West Virginia, was that she was offered a job less than 5 minutes away from her then boyfriend's home, and it was at a State Farm agency, and it was contingent upon her being able to move there. And then she quit her job at State Farm here, and that was all as a furtherance of her career. That was one of the big things that the reason that she was going to do this. And now she quit her job. She worked at another job. She worked full time. She said she was going to only work part time. There's been like it was this and it's this and this and it's like, and the testimony and the actions don't match. And she was going to have, and specifically, I believe that she said that plaintiff alleged in her motion that her fiance is, quote, supportive of a part-time work arrangement for her. His career is stable and he is well compensated, which will enable a more relaxed professional schedule for me. Yet she quit her regular job. She took a full-time independent contractor job, if you will, with no benefits. And then now and because of this financial affordability, because of her fiance's and now husband's income. And now here we are. We'd already agreed on this. This is something that they negotiated before Lisa was involved, before Ms. McNiff was involved, before I was involved. And now here we are saying, oh, well, wait a minute. That's not affordable now.
Oh, so it makes sense now. You took a lower paying job and now he has to pay for it. Your ex. No, ma'am, that's not how that works. You don't get to affect your ex because of your decision to work 5 minutes from your home. At this point, the new husband must be regretting his decision, seeing her decision-making capabilities, because once she divorces your ass, you're gonna be on the line for this bullshit as well. But let's see now what the judge thinks about all of this.
I mean, I think she needs to use her new financial windfall and she needs to suck it up. That was their agreement. This is, again, 1/2 share of childcare expenses is what they agreed to. And it's not included in the uniform child support order. This issue with regard to who's going to pay what for last summer is before referee Snyder. So this issue was already in front of him. And this is, again, another motion that the plaintiff has brought that we have to prepare for, get ready for. And we're just asking that the court uphold the current order of the court, the judgment of divorce, which is the court order by consent of the parties. Although Ms. Gentry indicated that she has paid her 50% of childcare, she has not. She's not paid anything this summer at all. And now we have attorney fees in addition. And it's the same subject matter that's already before Mr. Snyder, that he's already taken testimony as to these issues, in fact.
Yeah, I don't have to have that read. I've heard that probably 3 times already, Ms. Thomas. What I'm going to do in this matter is, obviously, the judgment of divorce provides for 50-50 in child care costs. It was by the consent of the parties. The court has not heard any reason why the court should invade and modify a judgment that was entered into by agreement of the parties, consideration of all the issue. The court is going to deny the motion. Ms. Thomas, you can prepare that order and submit under 7-day.
Your Honor, will the court consider our request for attorney fees?
I'm not going to at this time.
Okay, thank you.
Thank you.
Motion denied. To hear at the end of that she wasn't even keeping up with the 50-50 is just a cherry on the damn cake. Making a decision to earn less on purpose, and it's probably because the now new husband has enough money to support, is simply crazy, because you're now utilizing that as a weapon to get more money out of your ex, even though you negotiated in the divorce. This is Lilith from Inferno. I know it might be a new feeling for you, but now that you're divorced from your husband, you can no longer utilize him as an emergency piggy bank to substantiate any type of lifestyle that you want to live. The best comment in there is when a lawyer said that she has to just suck it up, because she understands that child support is for the children. It is not lifestyle support to support your new lifestyle. Your new job is not your ex-husband's issue. You need to grow up and be an adult. Shame this mom.
Shame.
Banish her.
Shame.
To the realm of ridiculousness.
Shame.
For she is unworthy.
Shame.
Of adulting.
Shame.
Responsibly.
Shame.
Walk her into the quarters.
Shame. 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 Shame.
Women like this will continue to make me sick to my damn stomach, but I'm so happy that at least of the court cases, of the ones that I can find at least, because there's some other ones where it doesn't work out that well for the guys, but I wanted to show that there is perhaps a switch to a degree where men can win in these family court situations because the judges are becoming accustomed to the bullshit that comes across their docket. All right, guys, that's the end of the video. Let me know what you think down in the description box down below. Let's continue to have a conversation about stuff like this. Have you been involved in custody cases that have gone awry, but then were able to be brought back up on track, either through use of a lawyer or not? Share them down below. Let's talk about it. Last but not least, my men's self-development community is going absolutely up. Join it. Link to it down in the description box down below. All 2025, we are expanding as well as amplifying with a keen focus on financial wellness, wealth building into the future. If that is your focus, click the link down in the description box down below, beam up, and let's get active. All right? Until next time, YouTube. Peace!
She belongs to the street.
Girl, don't hold my hand. You a mattress actress on the OnlyFans. Get your money, girl, but damn, how is that your only plan? What you gonna do when you get too old to strip and dance? Get up out your echo chamber screaming period and yes. You a low down dirty woman if you try to get knocked up by a high value man.